Hi, my name is Müslüm Yılmaz and I'm a counselor in the Legal Affairs Division of the WTO. Today I'm going to talk to you about the dispute settlement system of the WTO. This is the roadmap for the presentation. We are going to do an overview of the system first. Then we will talk a little bit about the pre-dispute stage, what happens before you decide to bring a case in the WTO. Then we will go through the main phases of dispute settlement, which are consultations, the panel process, appeal, and implementation. Implementation of the outcome of the process. And at the very end, I'm going to give you a few statistics demonstrating the level of the usage of this system by the members of the WTO. Now, the objectives of the dispute settlement system are set out in the DSU, in different provisions of the DSU. The DSU refers to the dispute settlement understanding, which is the WTO agreement that contains the rules of procedure governing dispute settlement. So I'll be referring to this legal text as the DSU in this presentation. So the various objectives that are set out in different provisions of the DSU are explained or listed on this slide. The main function of the system really is to provide security and predictability to international trade. In other words, it is to allow WTO members the meaning of the obligations and the rights set out in various WTO agreements so that these rights and obligations are well known by the actors that conduct international trade, which are the companies, which are the traders, and so that trade can continue flowing. So this is the function to provide security and predictability. By doing this, the WTO dispute settlement system also preserves the rights and obligations of WTO members by clarifying these provisions in the WTO agreements. One thing that also has to be underlined about the system is that it is different from the typical adversarial litigation system that you see in national judicial systems. The WTO dispute settlement system is not really meant to be such an adversarial system. The purpose of the system is to provide a positive solution to the dispute between the members, as I said, so that trade can continue flowing freely. So the ultimate objective is to make sure that the disputes are resolved quickly and so that members know their rights and obligations and trade can continue flowing. Now, the main features of the system, these are important characteristics that you should know. First of all, it is a system that is only available to governments. It's, in other words, only members of the WTO, the sovereign states, can use the system. In principle, private parties don't have any right to participate in dispute settlement. It is an integrated dispute settlement system, meaning that once you become a WTO member, the dispute settlement understanding applies to all disputes that arise under all of the multilateral agreements on trade. It also applies to the plurilateral agreements, but only if the two parties are signatories to the same plurilateral agreement. Now, the system provides for exclusive jurisdiction, which means that if a WTO member alleges that another member has violated a provision of the WTO agreement, the only forum where this can be alleged is the WTO dispute settlement system. Such claims cannot be raised in fora other than WTO dispute settlement. Compulsory jurisdiction means that once you become a WTO member, in a sense, you cannot run away from the jurisdiction of WTO panels and the appellate body, right? So you are bound to follow the DSU, which is also one of the agreements attached to the WTO agreement, for the disputes that arise from the implementation of the WTO agreements. Implementation of results. This is also an important feature of the system. In a sense, it means that the dispute settlement system of the WTO has teeth. In other words, it has provisions that aim at making sure that the outcome of a dispute is actually implemented by the respondent, by the defendant. Another interesting feature of the system is that it provides for a two-tiered dispute settlement mechanism, with the panel stage being the first tier and the appeal mechanism being the second tier. I'm going to explain to you at the end that we have issues right now about the appeal tier of the system, and discuss with you what that causes on the functioning of the system as of today. The last bit that I want to explain about the main features of the system is this notion of not binding precedent, which put simply means that WTO panels, when they are called upon to interpret a particular provision of the WTO agreement, they look at how the same provision has been interpreted in previous cases. The WTO panel, as part of its own process, also looks at prior interpretations by panels or the appellate body of the same legal provision. What should be underlined in this regard is that this is not a binding precedent system. We don't have the notion of stare decisis in WTO dispute settlement. The past rulings, past interpretations are not binding on panels, but panels may find them to be informing, may find them to be persuasive, and may ultimately decide to go in the same direction and come up with the same interpretation without giving it any binding value. Now, who are the actors in WTO dispute settlement? Of course, there are the parties to the dispute, the complaining member of the WTO, the respondent, right? Other countries, other members of the WTO may participate in a dispute ongoing between two members of the WTO. So if Australia brings a case against Brazil, for instance, the US or the EU or Mexico may wish to participate in that dispute as a third party. So you have third parties. You also have private lawyers who play a role. Often WTO members engaged in dispute settlement are represented by private lawyers. In this context, I should also mention the Advisory Center on WTO Law, the ACWL, which is an organism created for the purpose of providing legal services to developing country members of the WTO at reduced fees, those members when they are engaged in dispute settlement. So a developing country member of the WTO may either hire private lawyers or find lawyers from the Advisory Center on WTO Law, which is based in Geneva, like the WTO. Now, civil society, as I mentioned, the WTO dispute settlement mechanism is only available to the members of the WTO. It's a government-to-government mechanism. But civil society, in other words, NGOs, happened to play also a role by submitting what is called amicus curiae briefs, right? This happened in cases that involved measures that had an impact or a perceived impact on the environment. And in those cases, certain NGOs dealing with environmental issues, they submitted their views to the panel or the appellate body. And the current status quo in this regard in WTO dispute settlement is that panels or the appellate body may accept such submissions from these NGOs, from the civil society, but they are not required. They are not required to take these submissions into account in making their decisions. Now, a word about the institutional structure of WTO dispute settlement. The most important body that plays a role in the process is the dispute settlement body, the DSB. This is a political body. It is composed of the members of the WTO. In other words, each member of the WTO has a representative in the DSB. There is also the panels, of course, that play a role. There is the appellate body, as I mentioned. At two stages in the process, arbitrators may play also a role, which I will explain to you. Then you have, in some cases, technical experts who may also play a role in explaining technically complex issues to panels. You have also the Director General, the DG of the WTO, who can play a role, particularly in the composition of panels. And finally, you have people like myself, the lawyers working in the secretariat of the WTO, whose job is to assist the WTO panels or the appellate body in the discharge of their functions as dispute settlement organs of the WTO. Now, the legal basis of dispute settlement, as I mentioned, there is the DSU, but you should also know that there are also two provisions in the GATT 1994, namely Articles 22 and 23 of the GATT, that also contain provisions on or rules on dispute settlement, which still apply today, but they are of really a general nature, and for the most part, if not all, for practical purposes today, it is the DSU that governs the dispute settlement process in the WTO. Now, we should also mention that in addition to the provisions of the DSU, some WTO agreements contain special or additional rules, some certain special provisions on dispute settlement, which means that in disputes arising from those agreements, not only the DSU, but also the special provisions in those agreements will apply to that dispute. And in case there is conflict, the special provision in the relevant covered agreement is going to prevail over the provisions of the DSU. Now, what can you challenge really using the WTO dispute settlement mechanism? In other words, what is a measure? What is a measure for purposes of WTO dispute settlement? Now, the notion of measure is not defined in the DSU, but a certain definition has emerged from the case law, which basically stands for the proposition that any act or omission that is attributable, that can be attributed to a WTO member, may be challenged in the WTO. So this is a very broad definition of measure, and it shows that WTO members can take issue with a lot of the instruments that are adopted by WTO members, including their statutes, their regulations, their various other legal instruments, but they can also challenge unwritten measures by WTO members. So we had cases where WTO members, the complainants, managed to demonstrate to WTO panels the existence and the specific content of certain unwritten measures, and they were able to make claims about those measures. So that is also possible. So the notion of measure is very broad for purposes of WTO dispute settlement. Now, after these general remarks, let us move on now to the main phases of a dispute settlement process. The process starts with consultations. Consultations between disputing parties. So if, for instance, Australia brings a case against Brazil, Australia first has to submit a document, which we call a consultations request, in which Australia has to identify two things. First, the specific measure at issue. What is the measure, or what are the measures that Australia challenges? All right. And the second thing is, what are Australia's claims? In other words, which provisions of the WTO agreement does Australia allege that have been violated by Brazil? So measures and the claims have to be identified in writing in this document that is called the consultations request. The consultations request is going to be submitted to the WTO, and the consultations will start. If the disputing members manage to find a solution between themselves, an amicable solution, that is going to be the end of the dispute. If not, then the complainant, in our case, Australia, may take the process one step further and request the establishment of a panel. Now, similarly to consultations, the establishment of a panel is also kicked off by the submission of a panel request, another document in writing submitted also by the complainant, which also identifies the challenged measures and the claims presented by the complainant. This panel request is important because it determines the scope of the jurisdiction of the panel. which means that WTO panels can only entertain claims, can only make findings on claims that are identified in the complainant's panel request concerning, again, the measures that are identified in the panel request. All right, so panels can only make findings on the claims presented regarding the measures identified in the complainant's panel request. Now, the request for establishment of the panel is also directed to the DSP. The DSP is going to establish the panel. This will be an automatic establishment because according to the DSU, establishment of a panel is subject to the so-called negative consensus rule, which means that the panel is going to be established unless there is consensus against establishment. So because in our example, the complainant, Australia, will definitely be present at the meeting of the DSP where this issue will be discussed, there is going to be no consensus against the establishment of this panel. So the panel is going to be established automatically by the DSB. Following establishment, the next step is the composition of the panel. In other words, identifying the individuals who are going to function or serve as panelists in this dispute, who are going to be the members of this panel. According to the DSU, a panel may be composed of 3 or 5 individuals, but until now, it's always had 3 members. So we never had a panel with 5 members. The rule about composition is that the parties to the dispute, right, the respondent and the complainant, should agree on 3 names. If they do, those are going to be the panelists that will be serving or that will be in this panel. But if the parties do not agree on 3 names, then it is for the Director General of the WTO to appoint these panelists. I think in more than half of the cases so far, the parties have not managed to find 3 names or to agree on 3 names. And it's been for the WTO Director General to appoint the panel members. Let me mention that once again that third parties may participate in the dispute settlement process. They may participate in the consultations. They may also participate in the panel proceedings. Although it is possible for the respondent to stop certain countries from participating as a third party in consultations, that option is not available for the panel process. In other words, whoever wants to participate as a third party may do so simply by expressing its intention to participate in the panel proceedings as a third party. And the members who participate in a panel proceeding as a third party may also participate as a third party in the appeal process, if there is an appeal in the same dispute. Now, this issue of jurisdiction, we've already mentioned it. Now, the panel has been established by the DSP. The panel has been composed either on the agreement, through the agreement of the 2 parties, or by the appointment of the Director General of the WTO. Then the procedure, the panel procedure starts. First, the complainant, then the respondent present their first written submissions to the panel. This is followed by a first meeting of the panel with the parties. A portion of this first meeting is going to be dedicated to the third parties. It is called the third party session of the first meeting. So in the first meeting with the parties, the panel is going to hear oral views, right? Oral arguments of the parties. The panel will ask questions to the parties. The panel also will give a chance to the parties to ask each other questions through the panel. In the third party session, it is similar. The parties to the dispute will be present at the third party session. The third parties will have the right to make an oral presentation to the panel, and the panel may ask them questions and so on. Let me also add that the third parties may also submit a written submission to the panel prior to the first meeting. The participatory rights of third parties are limited to the period until the first meeting of the panel with the parties. In other words, as a general rule, there are exceptions to this, but as a general rule, the third parties don't have any participatory rights in the panel process after the first meeting of the panel with the parties and third parties. Now, after the first meeting, the complainant and the respondent will submit their second written submissions, their rebuttals, to the panel. The panel is going to take them into account and will organize its second meeting with the parties, only with the parties. At the second meeting, it's very similar to the first meeting. The parties will make their oral presentations, followed by by Q&A with the panel, and sometimes between the parties. At the end of the meeting, at the end of actually the first meeting and the second meeting, the panels typically send written questions to the parties. Right? At the end of the meetings, first and the second meeting, the panels typically send questions to the parties, written questions, to be answered in writing. All right. Now, so the second meeting is over, the questions are sent, responses to these written questions are received by the panel. That is normally the end of the interaction between the parties and the panel. The panel first issues what is called the descriptive part of the report, which provides, certain general information about the case, including a description of the history of the dispute, what are the measures at issue, the claims raised, etc. But there is no substantive findings in the descriptive part. The parties may make comments about the descriptive part. Then comes the real work by the panel, which is the drafting of the panel's interim report. The panel comes to a conclusion about the claims presented by the complainant and starts the drafting of its interim report. In this drafting process, the Secretariat assists the panel under the panel's, of course, strict instructions regarding the drafting of the report. The interim report contains the findings of the panel about the claims presented by the complainant, and it is sent to the parties to the dispute. So the complainant and the respondent, they receive the interim report. They get a chance to see the findings of the panel about the claims and defenses, if that is the case, and they can make comments. They always make comments. The panel takes those comments into account and issues to the parties what is called the panel's final report. That is the panel's final report. It is issued to the parties to the dispute first, and then it gets translated into the three working languages of the WTO, which are English, French, and Spanish. And once translation is completed, the panel report gets circulated to all WTO members as an official document of the WTO. As of the moment of circulation, the report is also available to the whole world through the WTO website as an official document. So whoever wishes to read that panel report can simply download it from the website of the WTO and read it. Now, once the final report is circulated to all members of the WTO, either it is going to be considered for adoption by the DSP or it's going to be appealed. If the panel report is appealed, it's not going to be considered for adoption by the DSP until after appeal is completed. If it is not appealed, then it's going to be adopted by the DSP. Now, like the establishment of the panel, adoption of the panel report is also automatic because it's also subject to the so-called negative consensus rule. Remember, this means that the panel report is going to be adopted unless there is consensus against adoption of the report, which will never be the case because the complainant is going to be present at that meeting. So the panel report is going to be adopted by the DSP automatically unless there is an appeal. Now, the appellate body, if you look at the text of the DSU, there is an appellate body. It has a structure. It is different from panels because while panels are appointed on an ad hoc basis, the appellate body has 7 permanent members, of which 3 are selected to decide a particular panel. The appellate body also has its own secretariat, which is in the WTO building, and those colleagues in the appellate body secretariat, they assist the appellate body in the discharge of its functions, including with the drafting of the report and so on. The one important thing to know about appeal is, or one of the important things actually, is its scope. Appeal is limited to issues of law and legal interpretations developed by the panel. All right. This means that factual determinations made by a panel cannot be reviewed by the appellate body on appeal. Factual determinations cannot be reviewed by the appellate body on appeal. Now, the powers of the appellate body can either uphold, right, approve a panel report, or modify it, make some changes, or reverse, right, disagree completely with the panel's findings. In some cases, the appellate body may also complete the analysis of the panel if certain conditions are met. When the appellate body reverses the panel's findings, it may or may not complete the analysis, depending on the factual findings made by the panel. Now, the appellate body reports are also going to be adopted through the negative consensus rule. So what would happen is that the panel report in the same dispute would come to the DSP, together with the appellate body report, and they would be adopted together, right? The appellate body report would be adopted and the panel report would be adopted as modified by the appellate body report through negative consensus. However, as of today, the appellate body has 0 members. There's no appellate body. There is no functioning appellate body for certain reasons. And therefore, we have this deadlock in the dispute settlement system, or a crisis, as some call it, because of the non-existence of a functioning appellate body. And that causes certain problems in the system, which I will explain at the end of my presentation. Now, the panel was established, composed. The panel did its job, heard the parties' arguments in writing and orally and so on, drafted its report. The report was circulated and it's been adopted by the DSP. Now, the next phase and the last phase in the process is, of course, the implementation of the panel's findings and the appellate body's findings, if there is an appellate body report in that same dispute. Without implementation, as you can imagine, the findings in the panel report would have no meaning. Now, what you should know as a matter of law is that as of the moment of adoption by the DSP, the findings in the panel report become international law obligations for the respondent. In other words, the respondent then comes under an obligation to do the necessary to comply with the findings and recommendations found in the panel report. All right. So the rule is immediate compliance. In other words, the DSU expects the respondent to immediately comply with the findings of the panel. Because the findings and recommendations of the panel, in a sense, become the findings and recommendations of the DSP as of the moment of adoption of the panel report. So the DSP's findings and recommendations have to be implemented immediately. In most cases, however, this doesn't really happen because it's not realistic. Why? Because typically WTO members, the respondents, they need some time to figure out how to implement those findings and recommendations. So they need time and they seek time. This is called a reasonable period of time. The respondent will seek and get a reasonable period of time. Either the parties will agree or the DSU is going to decide, or the matter is going to be referred to arbitration. In other words, if the parties cannot agree, then an arbitrator functioning under Article 21(3)(c) of the DSU will decide the length of the RPT, the reasonable period of time. Now, at the end of the RPT, 2 things might happen, right? Either the respondent has done nothing or the respondent has done something. If the respondent has done nothing, then the complainant may move the process further, right? and seek either compensation or resort to retaliation. But if the respondent took certain steps to implement the findings and recommendations of the DSP, then you have two options again, or two possibilities. Either the complainant agrees with the respondent that the steps taken by the respondent achieved compliance. In this case, the dispute is over, right? Or the complainant disagrees that the steps taken by the respondent did achieve compliance. In this case, the complainant may initiate a special procedure provided for in Article 21.5 of the DSU to have a compliance panel decide whether or not compliance has been achieved. Now, typically, this is the same panel. This is the original panel, the same three individuals, if they are available, who now act as a compliance panel. Now, the compliance panel is going to make a decision as to whether or not the measures taken to comply by the respondent have achieved compliance with the DSP's recommendations and findings in the dispute. This panel report may be appealed, in which case the appellate body is going to say the last word about compliance. In either case, if the last word in the compliance proceeding is that compliance has been achieved, that is the end of the dispute. If the last word is that compliance has not been achieved, then the respondent doesn't get a new reasonable period of time, nothing. Then we move to the next stage of the process, where either the complainant and the respondent sit down and agree on compensation, or the complainant may seek to retaliation against the respondent. Okay. Now, when we say compensation, we are talking about a trade concession given by the respondent to the complainant. So if the dispute concerns, I don't know, it concerns the imports of cement, right? The compensation may be about the imports of rice. It may be about the about another product, another sector. And the thing about compensation is that it is going to be applied on an MFN basis. In other words, whatever further concession the complainant may receive from the respondent as compensation, all the other WTO members will also benefit from it. This makes agreeing on a compensation quite difficult, and we only have had a very few cases of compensation so far. So in practice, you don't really see a lot of cases where the two parties agree on compensation when the respondent fails to implement the DSP findings and recommendations. And what you see rather is a move to request to retaliate against the respondent. Now, the complainant has to get authorization from the DSP for retaliation, right? There is no retaliation without DSP authorization. So what happens is that the DSP receives this request for retaliation from the complainant, and the respondent may object. Respondent may object to two things. To the level of the proposed retaliation. The respondent may say, look, I haven't achieved compliance. We know that. And so the complainant has the right to retaliate against me. But the level of the proposed retaliation is way too much. It's way higher than my violation, than the nullification or impairment that my measure has caused to the complainant. Or the respondent may also object to the procedure followed by the complainant in seeking authorization to retaliate. So in either case, once the objection comes from the respondent, the matter is automatically referred to arbitration. And this is the second situation in the dispute settlement process where arbitration actually plays a role. Okay. Perhaps I should underline that there are rules, of course, about retaliation. The most important one, in my view, is the level of it, right? And there, the rule is that the retaliation has to be, the level of retaliation has to be equivalent to the level of nullification or impairment, or damage, in a sense, right, caused by the measure at issue, right? So in other words, the retaliation, the level of the retaliation has to be proportionate to the level of damage caused or nullification or impairment caused by the respondent's WTO inconsistent measure. And there are also rules about the sectors that retaliation may target. And the rules say that in principle, if practicable, if possible, the retaliation should target the same sector, if not the same agreement. If not, it may go beyond the same agreement and cover a different agreement. Now, when the issue is referred to arbitration, often, as I said, the main task of these arbitral proceedings is to decide the equivalent level of retaliation, the equivalent level of nullification or impairment. And so at the end of the process, the arbitrator makes a decision about the equivalent level of suspension of concessions that the complainant may be authorized to carry out, the equivalent level of retaliation that the complainant may engage in, and that arbitrator's decision is final. It cannot be appealed. And note also that the arbitrator in this context typically, again, is the same three individuals who served in the original panel, acting now as an arbitrator under Article 22.6 of the DSU. The other arbitrator that I mentioned, whose job is to determine the duration, the length of the reasonable period of time, is typically a single person arbitrator, and it's not necessarily a member of the original panel. Now, this arbitrator under Article 22.6 makes a decision as to the level of retaliation that may be authorized by the DSP, and the DSP authorizes retaliation. All right. This is the end of the process. One thing that should be underlined about compensation or retaliation is that they are both temporary measures under the DSU. Neither compensation nor retaliation by the complainant may replace compliance with the DSP findings and recommendations in the relevant panel and or appellate body report. Okay, so therefore compensation and retaliation will only be enforced, will only be implemented until such time as the respondent complies with the findings and recommendations in the relevant panel or the appellate body report. These are temporary measures. The last thing that I would like to mention about the substance is that the DSU also contains certain provisions that provide for special and differential treatment of developing countries. And there is actually one article, Article 24, which deals particularly with the situation of least developed countries. One of these provisions that I would like to mention specifically here is Article 27.2, which basically says that the WTO Secretariat has to maintain experts in the Secretariat whom developing country members of the WTO may consult about DSU-related issues. And the Secretariat does have such experts whom WTO members, developing country members, do consult from time to time and seek answers to their questions relating to WTO dispute settlement. This is the end of my substantive presentation. I would like to give you a couple of figures now, statistical figures regarding the use of the system by WTO members since 1995. Since 1995 through the end of 2021. In this period, we've had 607 cases filed in the WTO, 607 requests for consultations filed by WTO members. There have been mutually agreed solutions notified in 135 cases. Panels were established in 312 cases, composed in 274 cases. Panel reports have been adopted in 198 cases. The number of EPEPA reports adopted is 123. Perhaps the other thing that I should mention, which you may find interesting, is the number of authorizations to retaliate, which has been 23, in this period between 1995 and 2021. So the system has been used quite frequently. In around half of the disputes, you should know that the parties managed to find solutions during the consultations phase. Right? So only around half of the disputes actually moved to the next stage, which is the establishment of a panel. This chart shows you the evolution of the number of cases filed, requests for consultations, which is the red line, the number of panels established, which is the yellow line, and the number of appeals in the same period, i.e. between 95 and the end of 2021. As you can see from the chart, there's been quite a few fluctuations in numbers. We started off with relatively high numbers at the beginning, which sort of gradually came down in between 97 and 2005. From 2005 through 2011, they stayed at the same more or less low levels, and then we started seeing a peak again. Until 2019, there was a sharp decline in 2020, and compared to 2020, in 2021, we saw an important increase again. Now, it is hard to tell to what extent this decline from 19 to 20 was due to the COVID pandemic and was due to the appeal crisis, which I'm now going to explain to you. I think we will see in due course what the relative impact of these two factors has been from 2019 to 2020 in the system. Now, the last statistical information that I want to share is this breakdown of cases, in terms of the agreements that were at issue. In other words, which WTO agreements were cited most in WTO disputes so far. In other words, what are the highest number of claims that were raised under these agreements? Now, the most frequently sort of challenged obligations or measures were under the GATT, right? So the highest number of claims were raised by WTO members under the GATT 1994. This is only normal, I think, because of the overarching nature, the general nature of the obligations that are found in the GATT 1994 regarding trade in goods. The next one in the list is the anti-dumping agreement. The next one is the agreement on subsidies and countervailing measures, followed by the agreement on agriculture, the TBT agreement, the SPS agreement, safeguards agreement, and so on and so forth. Okay, but this doesn't mean that the cases that involved claims under the GATT were limited to GATT claims. It doesn't mean that. Actually, what you see in practice is that although a dispute is mainly, when you look at the substance of the dispute, it's mainly an anti-dumping dispute, for instance, or it's mainly a subsidies dispute, or mainly an agriculture dispute, but it may also contain provisions, contain certain claims raised under the GATT 1994. This is the reason why you have the GATT 1994 at the top of the list here. Now, a couple of explanations here about the current AB crisis that we are in. As I mentioned, the WTO appellate body is supposed to have 7 members, of which 3 would form a division and would decide a particular appeal. Now, since December 2020, the the appellate body is not functioning because it has no member. Right? There is currently no member of the appellate body. And the reason for this is because of blockage by one WTO member of the selection of new members to the appellate body. The United States has been blocking the selection of new members to the appellate body because it is of the view that the appeal mechanism has certain flaws, right? Certain errors have been committed. The US has been saying for quite some time that that unless these concerns that the US has about the functioning of the appeal mechanism are addressed by WTO members, the US is not ready to agree to the selection of new members to the appellate body. So this is the reason why we don't have a functioning appellate body right now. Now, what were the reasons that were cited by the United States? One of them was the famous Rule 15 in the appeal procedures, which allows an outgoing appellate body member to continue serving, right, after the expiry of his or her term, to continue serving as a member until the end of a case of an appeal to which that appellate body member has been appointed. Now, the appellate body members are initially selected for 4 years, and their term may be extended up to 8 years. But this rule allows them, or allowed them, depending on how you see the current situation, to continue serving as a member even after the expiry of their term until they finish the cases to which they have been assigned. The US took issue with the legitimacy or the validity of this rule. The DSU says that an appeal should normally be completed within 90 days. The appellate body has been unable to observe this rule in some cases, and the United States also found this to be a problem. Another argument presented by the United States was that the appellate body in some cases engaged in the review of factual findings made by panels, which, as I explained to you, the appellate body cannot make. Why? Because appeal is limited to issues of law and legal interpretations developed by panels. The WTO appellate body cannot review the factual findings made by panels. But the US argues that it did this, and this is a problem. The US also is of the view that in some cases the appellate body issued advisory opinions, opinions that were not really necessary for the resolution of the dispute, and that it engaged in overreach. It made findings on issues that were, again, not needed to resolve the dispute. And the US also is of the view that the appellate body attributed to the case flow of the WTO, to past panel reports, and particularly past appellate body reports, some sort of binding characteristic, a binding nature, which in the view of the United States is not justified under the DSU. So for all these reasons, the United States decided to not agree to the selection of new members to the appellate body. And therefore, as of today, we have 24 appeals that are pending. I think of the 24, 10 were the appeals that were already pending when the number of the appellate body members came down to 0. And since then, another 14 have been added to the list because WTO members, one can say unfortunately, have tended to appeal panel reports since December 2020, which basically delays the implementation of these panel reports. And actually, a term has emerged to describe this situation. Some people call these appeals these days appeals into the void. Appeals into the void for the reason that these appeals these days basically, as I said, result in delaying the implementation of panel reports because there is no functioning appellate body. You appeal the panel report, it is meant to be referred to the appellate body, but because there is no appellate body, the implementation of the findings and recommendations in the panel report are delayed. But what is interesting, and what in my view is actually very good, is the fact that despite this appellate body crisis, WTO members, including the United States, continue bringing cases to panels, which you could argue shows that WTO members continue to trust the dispute settlement system, but one member or maybe several members, because some of the concerns raised by the US also happen to be shared by some other members. So some members have issues about the functioning of the appeal part of the process, but they all seem to continue trusting the panel process, so they are bringing cases. The big question, of course, is what is going to happen, right? How long is this going to last, and how long WTO members will continue bringing cases to panels, knowing that there is no functioning appeal mechanism, and that at the end of the day, their panel report may be appealed into void. Now, several sort of solutions have emerged in this period to find a way around this crisis. For instance, there have been ad hoc decisions not to appeal, right? In one case, for instance, parties agreed that they may appeal their implementation panel under Article 21.5 of the DSU, not through the normal appeal mechanism, but by using the arbitration provision in Article 25 of the DSU. Note that this arbitration provision is one that points to arbitration as an alternative to the normal dispute settlement mechanism. In other words, the normal mechanism being what I've just explained to you, starting with consultations, panel process, appeal, implementation, and so on. Arbitration is provided for in Article 25 of the DSU as an alternative to this mechanism. It's only been used once so far, so it's not really being used frequently by WTO members. But in this case, the parties decided that they may use arbitration, which is a voluntary mechanism rather than the normal appeal mechanism. There have been cases, there's been at least one case where the parties decided ex ante not to appeal a panel report. This also happened. And I should also note that in one dispute, the US itself, as respondent in the case, decided not to appeal the panel report. So the panel report has been adopted by the DSP. And lastly, in this regard, I would like to mention this interim appeal mechanism that has been proposed by the European Union, again based on the arbitration mechanism found in Article 25 of the DSU. So the EU came up with a multilateral appeal mechanism, interim appeal mechanism that has been signed. This proposal has been signed so far by 25 members of the WTO, this multi-party interim appeal mechanism, MPIA. This basically provides for an appeal mechanism that resembles very much the old appeal mechanism that we had in terms of the selection of they are called arbitrators under this mechanism, but it's very much like the selection of appellate body members in the old system. So in many regards, the proposal by the EU, the MPIA proposal by the EU, resembles the old appeal mechanism, including the powers of the appellate body, how interpretation is going to be done, and so on and so forth. This mechanism, as I said, has been signed by 25 members so far, but it's not yet being used in practice. But we are expecting it to be used in a couple of disputes, maybe in the course of this year, because there are indications that some WTO members who are in panel proceedings, both being parties to the MPIA may use the MPIA for appeal purposes. So again, the MPIA is an alternative appeal mechanism, an interim appeal mechanism proposed by the EU, endorsed by another 24 members of the WTO, which is based on the arbitration provision of Article 25 of the DSU. And in terms of its contents, it embodies a mechanism that very much resembles the old appeal mechanism. This brings me to the end of this presentation. Thank you very much for your patience and attention. If you attend the live session, I will be happy to answer your questions. Bye-bye and best regards.